So this project started back in 2022 in LA, when we put out an initial call for papers, looking to widen the conversation about ecocide, human rights and environmental justice, and encourage writing and participation from a broader group of people. We had a workshop in LA, an in-person workshop for most. Some of the speakers here today joined us then, and others joined online. We had some small publications, and from that evolved, the next step, which was the idea to turn it into a special edition of the journal, which Damien will speak about in just one moment. I just want to say maybe one more word about the Promise Institute for Human Rights. So we were founded in Los Angeles in 2018. I was the first executive director. I left Europe and went there to set up the Institute. And after 5 years, I handed over there and I moved to the Netherlands as an expansion move to set up the international office or European hub. And from our base in the Netherlands, we really focus, as well as on bringing students over and encouraging them into the world of international human rights and international law, we focus on the intersection of human rights, international criminal law, law, and the protection of the environment. So welcome everybody, really pleased that you're here, and I'd love to hand over to Damien.
Thanks, Kate. Welcome everyone. Great to see so many familiar faces and some new ones as well. So I just wanted to begin with a few thanks. Absolutely wonderful job, Leslie, in organising so much of this conference. And who's been working in-house, sometimes doing her annual leave as well. So big thanks to Jane as well. So I also wanted to thank our sponsors, the International Journal of Human Rights, and we have our journal manager at the back, Hugh. So welcome, Hugh. Nice to see you getting involved in the content as well, all the difficulties that you sometimes face. So to move on from what Kate was saying then, one of the things that we wanted to do with the journal in having a special issue on this topic is to basically bring the ideas to a wider audience. The journal's now absolutely enormous, has incredible downloads, etc. So in having this special issue, we realised that quite quickly we could get a lot more people interested in the idea of making ecocide an international crime, and principally the papers that have already been produced are downloading incredibly well. So really well done everyone, and when the special issue is finally finished, there's also the prospect of it being turned into a book. So much still to play for. But moving on from that then, I think one of the other reasons it was really important as well to get these papers into a journal like ours is it has significant policy impact. It gets read a lot, and it also can affect policy quite considerably. And I'm hoping that the more papers we publish in this field, the more impact it'll ultimately have. On the point of impact then, I would like to introduce our keynote speaker this morning, Baroness Boycott, who introduced the first bill on ecocide into Parliament. So, Baroness Rosie Boycott.
Thank you so much, Damien, and thank you all so much for being here, and indeed for inviting me to say a few words at the beginning of your day. I'm really sorry to say right from the start that I can't stay throughout because I'm incredibly interested in all the work that you do, but I have been guaranteed that the immense amount of you are writing papers and there are going to be full notes taken about what goes on. So I'm looking forward to that because, just to tell you a little bit, and I will speak more about it later, we put our ecocide bill in, and I have huge thanks to say here to Kate and to Jodie and to Damien himself, who all helped work on the law. The law locally is very tricky, as I'll discuss, but we did get it in, we did, and we would have got it debated had it not been for the fact that Parliament prorogued and the session ended. It's a quirky thing with private members' bills, but they get picked out of a hat. Good, bad, indifferent, I don't know. I suppose it means we have a kind of equality. But we will be back, and we will be re-looking at it, especially in the light of all the work that Monica's doing in Scotland, of whether we can fine-tune it, whether we can see better ways to make it work. And let's keep our fingers crossed, because it's the most important concept, even if it's difficult to implement. It's about what you feel and about how you look at the environment and about how it takes your heart and it takes your passion. But it's great to see that there are so many activists and so many lawyers and policymakers who all now want to talk about this. And honestly, you couldn't do this 5, 10 years ago. It has moved like lightning in a way like lightning through the discourse around the environment. And what is brilliant about this conference is that it recognises environmental justice as a global problem. And there are a lot of people from the North-South divide, and tonight some friends of mine are launching with the Soros Foundation, the North-South Foundation, a magazine called Equator, which is in fact entirely about trying to join up the problems that we face in the world, and I know Ecocide is a story they are going to cover very soon. So, climate and biodiversity doesn't respect borders at all, although politicians would like you to think that it does. I'm 74 years old now, and I've had a long and quite varied life. I'm very interested in a term that I came across the other day, the shifting baseline syndrome. And it's the process whereby ongoing damage to the natural world becomes completely normalized over time. Each new generation measures its idea of loss against what it had when it was a kid, not we had when we were a kid. So when I was a child in the spring, I was 8 or 9, I could lie down under a hedge and I could look up. It was at the bottom of my dad's garden, and I could see probably 4 birds' nests. In the next door field, we had so many cowslips. We made pancakes out of them. These are things that I can't see. My grandchildren are now 3 years old, and in my garden, I have lots of hedges, but there's no way that they can lie under those hedges and have a look. So unfortunately, that's going to be their normal, which was not my normal, and actually people's normals is fantastically important when you try to talk about the disintegration of the environment, what exactly we're trying to get back to and how far we're trying to get back to. And it makes it very difficult. So, even though back then, when the world, without my really thinking about it, did feel so full and abundant, outside the fence, there were ploughed fields, and I used to watch the tractors digging enormous, deep lines in the soil. And my cousins farmed in Oxfordshire, and they had a fantastic farm full of pigs and chickens and cows and everything you could think of. But down at the bottom of the farmyard there was a hut, and the hut had doors that opened like that, and across the doors was very crudely painted, but very large, skull and crossbones, keep out. You didn't really know what it was, except that you weren't allowed in there. So already, while the world was still very abundant, there were people like my cousins, and I like my cousins very much, and they were just doing what the Department of the Environment, the Department of Food, as it was in those days, was saying: we want more food, we want you to push your soil to the maximum. So they were putting poison onto the soil, which really, from in the post-war years, has been one of the processes, one of the key processes that has hurried up the enormous levels of environmental destruction that we see around the world from the food system. And just because I mentioned food system, I will say I came into the House of Lords on the crossbench. I filled in a form online, which if you want to do it, you put, how do I get into the House of Lords? They send you a form, and you say, this, I think that I have a skill you don't have. In my case, it was food politics in 2016, and nobody else could do it. So I come back to food a lot as to what, as I see as one of the main drivers of destruction. But of course, it wasn't for me until I led Silent Spring, some years later, that I actually started to put together. The stuff in that shed killed the birds. The stuff killed the soil. And the killing of the soil meant you had to start buying fertilizers, all sorts of other chemicals, in order to keep it going. It's a bit like, I have not had a facelift. Women who have facelifts and they start to fall apart when they're 70. The soil falls apart, which is what we're seeing today, increasing parts of the world and the globe that were arable, that are now dust bowls. When I was 19, I dropped out of university and I joined a newspaper called Friends, spelled with a Z. We were there just before I started Spare Room. We did a lot of environmental stuff. It was probably my first encounter with the idea that the environment was a living, breathing thing. And I well remember when Christopher Stone the lawyer from California who was trying to teach his children and his students rather, and they were really, really bored. So he pitched them the idea that a tree might have life, and he wrote an incredible paper called "Do Trees Have Standing?" And it's something about that name. It never has left my head. Do trees have standing? And at the time we wrote about it, we had pictures of massive redwoods, and you looked at them and you thought, well, of course they have standing, but what about this small plant down here? Does this have standing? But he made the first time that nature needs a representative, that nature is just as entitled to having a representative as we are. Over in California, as I say, Stuart Brand and the Whole Earth Catalog were publishing these stories. But how has my own life at that point moved on to feminism and co-founding Spare Rib? But to say the question's always haunted me, why don't we respect the rights of living things and indeed of animals? As I said, my work is about the food industry, but I am daily, and I will now be for the next 5 minutes, absolutely depressed and disgusted when I work out how many animals this room represents. Each one of us has 8 in a cage somewhere right now. And that is truly shocking. Not just what it's doing to the animal, but also what it's doing to our health, what it's doing to the systems that supply the food for those animals, all ways round. As I say, we can't even give an animal proper standing. I'm going to give a tree one, but it's not impossible. My joke always used to be if the British factory farmed Labradors. Anyway, I came to realise that we all have, and I'm sure all of you too, that we as a species have put ourselves at the heart of everything. The entire world revolves around Homo sapiens, which has meant that our wealth has been appallingly distributed, greedily distributed, and thoughtlessly distributed. We have left ourselves as a world no longer interested in safeguarding the environment, even though it must be apparent to pretty much everyone, especially like this week, but because of the hurricane, but I can't remember how many times I've stood up in the House of Lords and said, and this week, my lords, did you see the fire? Did you see the floods? Did you see the this? These things come daily. It's not like freak events anymore. And yet, weirdly, listen to the BBC, they would say climate. Well, they do sometimes, they don't always. I was very lucky enough, I worked with the Hay Festival for years, and I got to know James Lovelock. And I guess James made me understand, that everything connects. It's not just one piece here and one piece there. This is a connection. Like our bodies, if you get sepsis in the toe, it's liable to knock off your heart. We are in a functioning organism, and it's dependent on its nature, its neighbours. And I've also, again, been lucky enough to meet and know Partha Dasgupta. And again, I look at his work and I think, why doesn't someone take that seriously? Partha, as many of you probably know, was commissioned by the Treasury. The Treasury has never set foot in the world of the environment until they commissioned this report at the end of the 2018-2019. And they said, what's the financial cost of what we're doing? What's the financial cost of burning down forests and polluting seas and all this sort of stuff? Partha came back with incredible figures. This is going to crash the economy. This is going to destroy the livelihoods of practically all of us if we don't. Is anyone paying attention? Nix. It's and yet, right now, right this week, we are doing the planning bill in the House of Lords, and they are putting through houses on floodplains. I don't have any confidence, and neither do my colleagues who think the same, that developments which are meant to put under a system called biodiversity net gain, they're meant to put not just 100% of biodiversity back into the ground, they're meant to put 110% back. If they can't get it in on the precise spot where they're building the houses, they're meant to do it somewhere else. As a consequence, sort of weird consequence, some farmers are turning themselves literally into land banks. So you could bring up DAFRA and say, I'd like to buy 200 acres of land bank in Leicestershire and get it. It's truly difficult and weird. But we don't have houses. So much of this comes back to social justice. The head of Southern Water, when they got charged with treating sewage onto the south coast, he was fined, they were fined 92 million. And he said, it's cheaper to pay the fine than to do the repairs to the sewage system in order to stop this happening. So that's the world we live in. That is really why we need ecocide, because you cannot have people who walk around and say things like that. So I'd just like here to take a moment to say how amazed Jojo Mehta's work has been in keeping this going, and she's having a fantastic effect on the international stage. And curiously, there's many ways, and Jojo and I have had this conversation, that it's sometimes easier to understand ecocide on a global scale than it is on the local, because I think everyone, if we had an ecocide law, everyone would agree that Bolsonaro would be charged with ecocide for what he did with the forests. And that seems clear. It's much, much more tricky when you get into local things. Her courage is fantastic. And as I said, I did introduce the private members bill, and I'm really grateful to Kate and Jodie for helping with the drafting. But the bill is part of a broader effort to bring environmental protection into the heart of our justice system. Not just to say that the destruction of nature is unfortunate, to say that it's actually unacceptable. So the unacceptable cases that I can see, well, I mentioned the water companies. They should forfeit their homes, or they should go to prison. Drax Power Company gets away with large amounts of money based on a pack of lies, which is being revealed day after day, that they do not use waste wood to keep that gigantic power station going, which, by the way, accounts for nearly 50%. They are now proposing to put an Amazon site, whatever, data gathering site next to it as a justification for keeping going. So in that, you have a big complexity between government law, which wrongly class something as sustainable, and reality. However, we can get them on the specific fact that the wood, we've got whistleblowers, the wood that is in the system is not waste. It's early growth forest, it's thinning, it's not waste. And it's absolute bullshit for any government or any country to say that burning wood is carbon neutral, or in some way has lower carbon. It's just lower coal. Or it's exactly the same amount. In fact, a bit less, because obviously the coal is really compacted and carries a more amount of carbon stored in it. But it's the same thing. And you just look at it and think, how do you really think you could pull up the wool over people's eyes? I'm chair of Peers for the Planet, which is a group just celebrated our 5th birthday. We are vice chair, let's say that's good. And we're a cross-party group in the House of Lords, and we work to try to get climate legislation into everything that we can see. So we have got things like climate legislation into pensions. It's little. It says funders must have consideration of climate concerns when they make their financial decisions. But it's something. It starts to build towards frameworks in which companies can act. Companies like, say, Client Earth, that we work with, can start to set up a system around which you can attack a company or government for, it's like the Deborah Kissy, what was her name? I'm sorry. Whose child so sadly died of asthma. She has been able to bring cases because of parts of these bills that are in framework. So while I want to see an overall ecocide bill, we beaver away to say that we also need framework in. And again, in planning, there is a great deal that we're getting in to do with councils having to take environmental consideration. I'm doing one particularly about having councils or planning inspectors rather trained, because right now the subsidy systems are so complicated. I mean, they honestly take a brain surgery to understand them. So a councillor can't think head nor tail of it. Get them trained. The pressures now come from everywhere. I mean, I know there's a huge appetite for change, and I think a bold politician at this point, is going to really be able to, really be able to make a lot of change. I've spent so much of my life just trying to communicate what I care about. So I've campaigned in many aspects of environmental work, and mostly against sustainable food agriculture to waste reduction. And change is not just about policies or technology, it's also about the culture, it's about the way we think, and about the way we value nature. So It matters very much that we see these cases of ecocide as not separate. They are massive and they are happening everywhere. And that's why the Ecocide Bill is very important, because I believe that it's partly because it's an idea and it takes root in your heart, and partly because it actually sets in motion a legal structure to prevent some of the worst damage. That's not to say we shouldn't still fight for more everyday laws, which will penalise people. Fly tipping will penalise all of that. But I'm, working on defeating the chicken farmers on the River Wye. Very, very they're owned by companies in America. They're directed from here. The sheds have been put up there. And so you have very complex matrix. And I believe we have to be working at all these levels all of the time, supporting the groups that work on the Wye and supporting the ecocide. So we have a good history in the UK, contributing to international law. I think we have to keep that going. I mean, we say we're proud of abolishing the slave trade. Actually, we paid off the slave trade. I sometimes wonder if we need to pay off. But we have to lead domestically. This conference is incredibly important because it brings together all of you from really different places. And change is only going to happen if it can happen across borders. And of course, any environmental change means a change for the better in social justice. I have always long thought that when I started working in the food industry and I learned more about it, I thought, you can't save the world unless you change the food industry. I now think you can't even begin to change the world. I think food is at the bottom of so many of the things that happen. It's at the bottom of the way we've trashed the oceans. It's at the bottom, or the top, wherever, for the reasons why we've trashed the rainforests. It's so much as well at the bottom of why we're running out of water for agriculture, about the reasons that soils get poisoned, and it's a situation where you apply the capitalist model, which unfortunately now runs the world. If you apply that to food, actually you have a complete disaster. So I'm not saying I have the answers, but the answers certainly within food are relocalise, 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 and take the poisons out of the system. The task now, let's finish on this too, is to keep the momentum going. In the words of Partha Dasgupta, runaway carbon emissions and biodiversity loss interfere so much with the workings of compliance that humanity faces a problem that it did not in the past. A human-created possibility of our collective extinction. Death is coming for all of us, yes, it is inevitable. But why can we not accept this collectively? As the Partha said in closing, risks of extinction are probably inevitable. In contrast, we could be responsible for not having that happen if we changed our behaviour. We can't protect our human rights and indeed our futures unless we protect the living world on which we all live. Thank you to the organisers for bringing us together. Thank you very much for inviting me, and I hope a few remarks made little sense. Thank you.
And this morning's panel is really on corporations and colonialism. I'll go on to introduce the content and then the panelists, basically. So our panel looks at and examines the proposed climate ecocide, and how it can serve both as a legal innovation and a conceptual lens for addressing interlocking arms. It brings together diverse regional perspectives, and as we'll see, we have panelists from who will discuss Latin America, we will discuss more island developing states, we will discuss Africa, and we'll discuss South Asia. But also these panelists are from these regions and present voices from these regions. The discussion will consider the value and limits of ecocide as a response to corporate-driven environmental destruction within neo-colonial context, and as a pathway toward advancing human rights and environmental justice. And I think this particular panel is important for a couple of reasons. First of all, it centers the discussion we're having today within colonial histories and transnational histories that humans have had and have engaged in. And I think when we look at the environmental harms that have been experienced, perhaps the global south and small island developing states are truly feeling the consequences of environmental harms a lot more, and they have less capacity to respond to them. But also they have not highly contributed to these environmental damages. So the element of coloniality that underpins the interaction between developing parts of the world and developed parts of the world continues to define and underpin how corporations operate. And coloniality does not just end with how corporate structures are set up, how legal frameworks respond to them, but also it underpins how we make value, how we create value, how we engage with the earth, how we consider concepts of ownership, and even how we respond as lawyers to environmental harm. The second element that is truly a strong element that underpins our discussion is the question of extractivism. Extractivism is not just about the process of extracting, but it's also how we exist and how we engage with the earth around us. And so this particular panel has interesting discussions that engage with indigenous human rights groups and indigenous people in the way they respond, engage with, and understand the process of value creation, the way they push back against dispossession, concepts of ownership, destructive value systems, and insisting on restoration and coexisting as opposed to displacement. And perhaps the most interesting element with the panel is, for me, a question of wondering whether ecocide as a crime responds to these value systems that exist within developing countries. Is it capable of reflecting them? Is it capable of not only just being responsive, but also preventative? And so that is what is important for our panel. I want to introduce our panelists. First of all, present their content and then bring them up to the front. We are going to have 4 panelists today. We have 2 panelists that are online, Dr. Tameka Samuel-Jones and Dr. Jonathan Lijoblad. They'll be joining us online, but we have also got panels that are in the room, Dr. Felix Dube and Ms. Krishnee Appadoo. So Dr. Samuel-Jones is an associate professor in law, governance, and accountability at York University in Toronto. She is also co-director of York University's Center for Research on Latin America and the Caribbean. Her research examines the implications of Canadian extractivism in the Caribbean and environmental crime, injustice, and Afro-indigeneity in that region. Her most recent publications were dedicated to challenges of Jamaica's indigenous Maroons. Dr. Felix Dube is a lecturer in the Department of Public Law at the University of Venda in South Africa and the editor of Jukla's Environmental Law and Cybercrime. He also serves on the South African Human Rights Commission's Section 11 Committee on Climate Justice and the Climate Justice Lead at the Legal Center for Business, Human Rights, and the Environment in Africa. Dr. Dube's work explores the intersection of environmental law, human rights, and democratic participation, with a focus on climate justice and indigenous jurisprudence. Dr. Jonathan Lijoblad is an associate professor at the Australian National University College of Law. He received a PhD and JD from the University of Southern California, and an MS from University of Washington, and a BS from California Institute of Technology. His research explores the challenges in promoting international norms within developing countries using case studies involving human rights, indigenous rights, and the environment. His research makes interventions in the literatures of international law, law and society, rule of law, human rights, environmental law, and law and development. Perhaps what's most interesting about him is the fact that he was born in Myanmar and is a member of the PAO Indigenous Peoples, a group in Sweden, and grew up in Sweden and the United States. Lastly, Ms. Krishnee Appadoo, I won't pronounce her mid-name, Appadoo is a senior lecturer in law at the University of Mauritius, where she teaches environmental and climate change policy and law. Krishnee is the founder and CEO of Climate Justice Compact, a pioneering social enterprise promoting environmental justice in small island states. She's also the co-founder and director of Mind Matters Mauritius, dedicated to mental health awareness and support. I want to invite the 2 panelists in the room to come and sit with us here. They will present first, and then we will have the panelists online coming in later.
Good morning, everyone. I'll make the start. Thank you very much for the introduction, Olivia, and I wanted to thank all the organizers for this wonderful opportunity. So I'm Krishnee, and so my presentation is on the link between ecocide and environmental justice, and it will be through a study of small island developing states and Latin American countries. So, of course, for the purposes of 8 minutes, I won't be able to cover like everything that I want to, but it's just a glimpse of my paper. So the paper explores the relationship between ecocide, environmental justice, and corporate accountability, and as Olivia has said, the link with colonialism. So it focuses on colonial legacies shaping environmental harm in SIDS and Latin America. So in terms of the definition of ecocide, I will allow myself to define it because I'm the first person to speak today. So it's the unlawful or wanton acts causing severe long-term environmental damage. And as everyone knows, it is being proposed as the core international crime under the Rome Statute. So through my paper, I argue that giving a legal recognition in terms of the crime of ecocide, not just through the ICC, but also through regional and domestic systems, we will be bringing transformative, it's a transformative tool for accountability, especially for corporations and governments involved in crimes against nature. So when we speak about environmental justice and why does the paper focus on environmental justice, it emphasizes accountability for harm, especially for vulnerable communities. And as Olivia has just mentioned, all the different papers in this panel will be looking in some form of, at some form of vulnerable groups and how they have been impacted by crimes against nature. So in the paper, I argue that ecocide law offers a mechanism for redress, as I've mentioned, not just through international law, but through regional and domestic law as well. So ecocide and environmental justice, they are intrinsically linked. And why? This is because environmental justice at its core seeks to empower those who have been affected by environmental harm, especially those bearing the brunt disproportionately of damage, and we're seeing that, you know, the storm in Jamaica, the harm that's being caused, and also like as all small island developing states and also countries in Latin America and also around the world. So, and also making those who have committed these crimes against the environment and the climate accountable for their actions. So it is increasingly focused on studying the relationship between profit incentives, the unsustainable production of exploitative labor practices and differential exposure to pollutants, and this has been highlighted by the Human Rights Council resolution of 2021. So this makes environmental justice share a close rapport with the aim of making ecocide gain the status of an international environmental crime, which is to end the culture of impunity when it comes to irreversible damage to the environment. So we have several environmental justice movements through activism from indigenous communities in Latin America, Asia, and the paper focuses on Latin America and all parts of Africa. And Australia tends to emphasize the interconnectedness of people and the environment instead of making a distinction between humans and the natural environment in which we live in. And the paper at some point focuses on the change relationship that we must adopt in terms of nature, not looking at it with a human at the center, which is anthropocentrism, but ecocentrism. So environmental justice emphasizes accountability, as we've mentioned, for harm to vulnerable communities. And Valerie Cabanes expressed in strong terms that by destroying the ecosystems on which we depend, and I'm quoting, we are destroying the foundations of our civilization and mortgaging the living conditions of all future generations. And this is no less serious than war crimes, crimes against humanity, or the crimes of genocide or aggression that we find in the Rome Statute. So this paper also goes into intra and intergenerational equity, because if we're speaking of ecocide, at the same time we're speaking of environmental justice and not protecting only this generation, but the generations that are coming after us. And the paper also talks about common but differentiated responsibilities in terms of what is the responsibilities of states that have contributed the most historically to harms against nature. And it also looks at the global north and global south dichotomy. So it looks at colonialism, decolonization, and environmental harm. So colonial extractivism has led to entrenched environmental degradation and is continuing and enduring patterns of environmental injustice. So, for example, in the paper, we look at land, resources, and labor exploited for profits by corporations, and how the legacy of coloniality lives on incorporate neo-colonial practices. So, for example, modern corporate practices often replicate colonial frameworks, and we have corporate complicity in these actions. For example, transnational corporations are shielded by weak regulations when they go and set up in Latin American countries, African countries. And also, we look at how profit over planet this is the mindset that is dominating extractive industries. So, and we argue that potentially international ecocide law could pierce corporate impunity. So in terms of corporate accountability, corporations are, as we've seen, the major drivers of environmental harm through pollution, loss of biodiversity, deforestation, climate change. And we try to look at whether Ecocide would allow the ICC prosecution to be able to prosecute corporate leaders. Okay, to what extent would that be possible? And in connection with environmental justice, for example, an Ecocide investigation might help shine a light on extractive imperialism. But there are some scholars who argue that the Ecocide won't do, the crime of Ecocide won't do, that because the unlawful and wanton requirements make allowance for some use of resources. But we argue that the wanton test requires that any project needs careful justification which can help better expose the real harms and costs of a project. Therefore, there is a chance, we argue, that international ecocide law could pierce, as I've mentioned before, corporate impunity. So, as I've mentioned before, and as argued by Gillett, the ICC's framework currently is focused on anthropocentrism, and we believe that there needs to be a shift towards adopting an ecocentric approach, but this is riddled with challenges, and because such a transformation will veer the attention towards the interests of both people and planet. So such a stance will enable the court to consider principles of environmental justice through the application of international human rights law, international environmental law, and international humanitarian law, as well as climate change. So an integration of the crime of ecocide under the Rome Statute would provide the impetus to integrate consideration of extractivism and neocolonialism, which are forms of social ecological violence, as identified by Minkova. So this is extremely important for environmental justice, as the latter also seeks to decolonize environmental and climate change law, with colonization having had a most damaging impact on natural resources and continuing to do so in a range of colonies across the world. So we argue that the environmental crisis faced by the world has been described as cementing power imbalances in society, and we argue that by integrating ecocide into the Rome Statute would be an effective way, it is believed, to change this power dynamics and empower peoples and communities to be on an equal footing when the environmental rights are being considered, and also protect at the same time the rights of non-human species that cannot defend themselves. So then there are case studies. Of course, I won't go through all the case studies of Latin America, Africa, and small island developing states. In Ecuador, for example, oil drilling. In Nigeria, Shell's role in oil spills in Ogoniland. In Mauritius, we had the Wakasho oil spill. And we also had the landmark Ecocide case, which gave legal standing for NGOs to be able to bring cases in front of the Tribunal for Environmental Protection. And of course, as has been mentioned by Baroness, the deforestation in the Amazon, and also momentum for ecocide legislation in several countries around the world, especially in Latin America, Mexico, Brazil, and others. So I won't go into detail in Mauritius, but we look at the Wakasho oil spill, which happened in 2020 at the height of the COVID pandemic, which was a tipping point for green litigation in Mauritius. And there are several people, because we do not have public interest litigation in Mauritius, so there are several NGOs and private individuals that started private prosecutions against the company that caused the oil spill and against the Mauritian government as well, that did not take enough steps in terms of mitigating the event. But unfortunately, their cases failed because we do not have public interest litigation. But after that, we had elections, and the new government promised to come up with PIL and also enshrine the rights of nature into our constitution. So we're hoping that that's going to happen soon. But ecocide has not, unfortunately, been explored yet by the legislatures in Mauritius. So in terms of policy and legal pathways, we proposed to include, of course, ecocide not only as a crime under the ICC, but in national legislations, which we believe is very important, and push for environmental rights in constitutional reviews, recognize rights of nature in legal systems as well. And we also talk about the role of civil society, which we believe is very important, because we believe that leadership should start from the bottom to the top. So, for example, we have strategic litigation and mobilization in Mauritius, like for Ecocide, the Iranian Senior Women for Climate and Protection, which was an NGO in Switzerland, Pacific Island Students Fighting Climate Change in Vanuatu, that brought the ICJ advisory opinion on states' responsibility for climate change. And we believe that civil society should be a key player in environmental governance and take a leadership role in bringing forward ecocide in national, regional, and international law. So finally, the recommendations are integrating, as we've mentioned, ecocide under the Rome Statute, introducing ecocide into national laws, decolonizing environmental and climate change governance, and moving from anthropocentric to ecocentric legal paradigms, recognizing indigenous knowledge, very important, and my other panelists will be discussing that, intergenerational equity and rights of nature, strengthen civil society and public interest litigation, build global South alliances for ecocide recognition, and also we need global North allyship when we're doing that. So that's what the paper is about in a nutshell. And so thank you very much for your attention, and I look forward to listening to my other panelists and to the others later.
Thank you so much for this opportunity and for the introductions, Olivia, and also to the organizers of the conference and those who are working on the background to ensure that I'm actually arrive here and that I'm able to present. Thank you so much. So today I want to speak about ecocide and crimes against the environment from an African perspective. I want to speak about the African dimensions on the law of ecocide. I should have put the law in quotation marks because it is still developing. So I'm not going to spend much time on the definition of ecocide because we have the experts here, so I cannot preach to the converted. But I just want to map the global landscape or the global campaign when it comes to ecocide, just as a refresher. We already know that there are current acts that are underway to establish ecocide as a fifth crime under the Rome Statute of the International Criminal Court. And we also saw in 2021 the independent expert panel giving us a working definition of ecocide, which you see on your screen. And then interestingly, from 2024, we see a formal proposal to the United Nations Secretary General for the amendment of the Rome Statute of the ICC to specifically include the crime of ecocide. And this movement is pioneered by the small island states. You've got Vanuatu, Fiji, and Samoa. They're being supported by the EU as well as countries like Belgium. So the idea is to eventually have a statute, an international statute, and local laws that will regulate the crime ecocide. All right, but I want to first, before just proceeding, to map up our argument as we put it in the paper, and I'm just going to quickly read it for you. Our argument is that the current efforts to define ecocide in international law often isolate the discrete acts of environmental harm that are derived from transnational histories and political economies that enable them. We argue that in many African countries, ecocide is experienced not merely as an environmental issue, but as a reality that is shaped by colonial legacies, extractive capitalism, and the enduring regulatory asymmetries between corporate actors and states. We build on scholarship that situates ecocide within broader systems of capitalist accumulation and epistemic dominance. We've already spoken about that. So we argue that in Africa, ecocide requires confronting the interactions between transnational corporate power and the region's distinct historical, economic, and regulatory conditions. This is our argument, and that brings me to our point of critique today. So we ask whether is the debate on the meaning of ecocide as currently framed missing the real problem. And we want to focus on the one term that has attracted a lot of criticism. As an academic, I feel at liberty to criticize what others have done. Yeah. So we focus on the use of the term wanton, which we find very much in international criminal law. And it has been interpreted within the ecocide definition to mean acting with a reckless disregard for damage which will be clearly excessive in relation to the social and economic benefits that are anticipated. So we argue that this then embeds a cost-benefit logic that is actually confronting the idea of sustainable development. So we see that it has become a very contentious part of the definition. It has been criticized for ensuring that very foundation of sustainable development and represent a paradigm that has itself been critiqued for failing to prevent ecological degradation by perpetuating the seeking of balancing economic activity with ecological degradation. So there are arguments that the wanton part of the definition, although it aligns with international criminal law, it actually presents ecological degradation and economic development as simultaneously legitimate aims, and it forces the court into a subjective and political commentary on what is good and what is not good. So at the end, what we see a situation where there is a risk that the law might create a system that prosecutes a few bad apples while actually allowing the structures that enable ecocide to thrive, to continue working. This is our main argument. So let's then come to Africa and look at what exactly are the colonial roots of ecocide. We know that the issue with Africa started as long back as the scramble for Africa in the 18th and 19th centuries. So when colonialism started in Africa, it was more than a subjugation of peoples, but it was actually an ecological project that was intended to replace the very diverse African ecosystems with export monocultures. We see palm oil production, copper production. In countries like Ghana, for instance, vast tracts of land had to be cleared in order to make way for cocoa production. And for that to happen, there was a need to then erase African eco-epistemologies, how the Africans related to their communities, how they related to their environment, and how they interacted with nature in general. And these were replaced with Western concepts of property. It locked Africa into an extractive model. So for instance, look at South Africa and how the gold and diamond rush created a system in which the country's pursuit of energy actually was in sync with the gold and diamond production. That's why even today, South Africa derives 7% and more of its energy from coal. All right, so what has been the result of that? The result has been that there has been what we term, or what has been termed by also other scholars, the offshoring of ecocide. After the end of colonialism in Africa, we see the replacement of those systems with new legal and economic architecture that is grounded on neoliberalism. And part of that has been what we call neoliberal legality, where you intentionally create laws within the environmental context, for instance, that are meant to protect the environment, but those laws are actually perpetuating the exploitation and degradation of that environment. So you create these very beautiful laws, but you ensure that the implementation mechanism is so weak, or that there are loopholes that can actually be exploited. So the result is that is as follows. You've got a system where global north states, which we call the home states of the multinational corporations, use bilateral investment treaties and also demand stabilization clauses. That allows global north corporations to come to Africa and do what they do under legal protection of their home states, and also with stabilization clauses that say, as soon as this company has started this project or upon the signature of this contract, the environmental law cannot be changed. Meaning that if that company then comes and starts operations, but it is degrading the environment or engaging in ecocidal state, there is nothing that the African state can do, because it is bound by the bilateral investment treaty for it to freeze the implementation of its environmental law. So what then happens to the global south states? You see what could be termed a race to the bottom, because they are in need of foreign direct investment. So they are going to negotiate for these companies to come through, and some of them have been willing to give up some part of their regulatory sovereignty in order to allow that to happen. You end up with a system where there is regulatory capture and weak enforcement of environmental law, leading to further degradation of the environment. So I could then sum up the whole idea that this is a system that is designed to offshore ecocide. The profits flow to the global north, of course, and then the ecological and social ills of it remain in Africa. I want to give just one example. There are many examples within Africa of ecocidal states, but of ecocidal activities. But I just want to give the example of the Niger Delta in Nigeria. It has experienced a series of what could be called oil spillage accidents. But if you actually look at it, you can't really term it as accidents, because you can't have the same accident happening over a period of 50 years. In 2024 alone, there are reports that there were more than 1,500 oil spillages. I think last time that I checked, the exact number was 1,514 oil spillages. So as a result of that, farmers who depend on fishing can no longer fish because the fish are dead, the water is polluted. Those who depend on that water for other agricultural activity cannot use it because it is totally polluted. So why has that been allowed to happen? It's quite several reasons, but what we see is multinational corporation negligence, and also these companies have been able to do what they do because they receive a lot of diplomatic support from their home states, like I've spoken about. So as a result, there is a system of weak liability. In some instances, big companies like Total, for instance, they don't come and establish themselves. Instead, they create small subsidiaries to which they are not directly linked. So when those subsidiaries commit acts of ecocide, they just close them off, or they distance themselves, or they argue that they are going to look at it, and as a result, there is no real liability for it. So as a result, you also have something that we call an accountability war of attrition. That you go after a big corporation like that, you're going to be tied in court for 30 years. I've given you the example of the Ejama Epuku case, which took more than 30 years for it to be settled eventually. All right, so what are Africans doing about ecocide? Is there anything that they are doing in order to criminalize ecocide as a crime in international law? So what we've been seeing is a movement from the object of the ICC to rather the subject of its agenda. The DRC, for instance, which is one of the states that is suffering devastating damage from the green movement, has become the first African nation to formally endorse an amendment to the Rome Statute of the ICC in this regard. We also saw in July 2025 the African Ministerial Conference on the Environment that actually declared that environmental protection will now be one of its continental priorities. There is a minor spelling error there. And then in October 2025, we also see the African Commission on Human and People's Rights together with the NGO Forum on the continent, resolving to support ecocide as an international crime. So this is a strategic reappropriation of international law to have global South justice requirements. But I think all these efforts would not have happened without the tremendous advocacy work that Kate and others in this room have done over the years. All right, so how are Africans actually, what are they specifically advocating in addition to the amendment of the Rome Statute of the ICC on ecocide? The debate is also moving, beyond criminalization. Because what is happening is when an international crime is committed, in most cases, of course, there will be criminal liability, and that's the end. There is often little regard for the victims of those crimes. So when Africans are supporting an amendment to the Rome Statute, they are arguing that there should be a need to repair the structural and historical harm that has been committed. And they are achieving this in three ways. The first one, they are demanding reparative justice. They are calling for an ecocide fund that will run parallel to the loss and damage fund for ecological restoration and community health. And secondly, they are arguing for legal pluralism, integrating African cosmologies that have been replaced, as I've spoken about. So the harm in this case in Africa is not just about the damage itself, but it is in the rupture of the sacred relationships between humanity and nature. And then they are also engaging in what we can call community-led accountability, where you are empowering grassroots institutions for justice and healing within those specific communities. I wish we had more time to speak about this subject, but I think I will end here. Thank you so much for listening.
So thanks to the conference organizers and the audience for letting me speak remotely. I'm extremely grateful for that. I'm extremely grateful for the opportunity to share the space today with the other speakers and some very compelling presentations. And I would also thank Olivia for guiding us throughout this discussion. I'm going to try to keep my presentation a little bit brief, so I may cut short some of my comments on these PowerPoints, but my article is available on the journal website, and I'm just providing the DOI link there just in case anyone is curious. With respect to the paper that I have in the journal, the starting point is really more a reflection about the issues that I see in Myanmar and how it might fit or not fit within the discourses on ecocide. And in particular, on a superficial level, given the environmental damage that's happening in Myanmar as we speak, it would look like a potential promising case for future efforts at prosecution should ecocide become part of the Rome Statute. However, during this presentation and in the paper, what I comment on is that with some reflection, it's not an easy, straightforward fit, and there are a number of things that need to be addressed or that we would have to sort of work on to make this a feasible possibility. The starting point for the analysis in the paper is really about trying to think more broadly about ecocide. So I go through a range of definitions that have been proposed for ecocide. I don't try to do a comprehensive review of the various definitions. Instead, the point is to try and identify a select sample of definitions that serve the illustration of a range of different perspectives to indicate the sort of the scope of ecocide discourse. And in particular, I look at 4 different draft definitions. There's Richard Falk, this is coming out from 1973, Polly Higgins with the model law from 2010, and then Mark Allen Gray in 1996, and the independent expert panel, which is more recent in 2021. These are out of order intentionally for reasons that will become more apparent within about a couple of slides. I'm not going to read through all of these definitions as a matter of time, but I am showing them to the audience and on the screen just as a way of indicating the differences in the range of approaches that are being circulated in terms of defining ecocide. So Richard Falk has more of a military focus. Polly Higgins with the model law from 2010 was looking more at the issue of peaceful enjoyment. Mark Allen Gray was bringing up the issues of negligence or deliberate activities. And then the independent expert panel brought up the issue about the state of mind regarding knowledge about the likelihood of severe or widespread damage over the long term. Within this particular discourse and these discussions between these various perspectives on ecocide, I look at the issues in Myanmar as very much a complex situation involving multiple factors. I use a framework of intersectionality. Intersectionality historically was a theoretical concept that dealt primarily with identity, but I find it a very useful tool because it deals with the issues of power and power dynamics. And there have been previous studies involving intersectionality in indigenous peoples that discuss the issue of power dynamics that played out across a range of issue spaces and how that impacts the formulation of approaches and understandings about the issues that challenge indigenous peoples. So within Myanmar itself, just for those in the audience who are not familiar with the country, there are a number of, there's more than 144 ethnic minorities. There is a growing indigenous movement that's been playing out over the course of the past 10 or 15 years. All of these groups have some form of relationality to the environment. And so what this means is that their sense of identity, their sense of self, their sense of culture, very much in some ways the political, legal, economic, and socio-cultural components that describe their distinctiveness are environmentally contextual. So in other words, it's specific to a particular location, particular ecosystems, and their continuing access and connection to those kinds of locations. This is in conjunction with ongoing issues of self-determination. So ever since post-independence, from 1948, there has been unending conflict in the country. It's been perpetual. And a lot of it has been tied to various groups, particularly ethnic minorities, and then the indigenous movements now that have been asserting various forms of self-determination that go from autonomy to outright claims of sovereignty. And a lot of these issues have flared off and on over the course of the country's history. Concurrent to this is the issue of the environment. It's sort of the locus underlying this, that there's a territorial claim. Self-determination is tied to access and preservation of relationality to the environment. This is also simultaneous with demands for economic exploitation. And so you have both the military as well as the various indigenous minorities that seek control of the natural resources as a revenue stream. And unfortunately, as in many countries, the majority of Myanmar's natural resource industries lie predominantly on indigenous lands. So 40% of the land within Myanmar is what you would consider to be indigenous or ethnic minority territories, while at the same time 60% of the natural resource industries lie within those territories. What's not helping at all is that within the past few years, there's been a growing international awareness that the natural resources within Myanmar are now connected to transnational organized criminal networks that operate across multiple sectors that cover natural resource extraction, narcotics trafficking, arms trafficking, and human trafficking. Another angle that is present within Myanmar is an issue of gender. So the perceptions of the environment, the aspirations regarding environmental policy, natural resource use reflect gender disparities. And under the current circumstances in Myanmar, this is becoming more significant because gender-based violence is becoming, or has been, a major tactic of the Myanmar military throughout all of its efforts to suppress dissent. Since February 2021, all of these factors have been exacerbated by the pro-democracy conflict. So in February 2021, there was a military coup, and under the resulting nationwide protests and resistance movements that were against the military coup, the Myanmar military, or the Tatmadaw as it's called, has escalated its natural resource extraction to try and finance its activities to suppress opposition in the country. So taking the situation in Myanmar, in the paper, I then tried to match it against the various definitions to highlight some of the complications that I see. Two of the definitions seem to be more promising, so Richard Falk and Polly Higgins. However, in both cases, there's a certain measure of inference that has to be exercised in terms of how well these two approaches can deal with the intersectional complexities that are playing out in Myanmar right now. With Falk's case, one of the major issues that at the time he formulated his Ecocide Convention in 1973, his attention was on the U.S. involvement in Vietnam. So it was a very different kind of environment, and that was very much a situation where you had a foreign military undertaking actions within a domestic space, whereas in a place like Myanmar, it's a domestic military acting against its own domestic population. With Polly Higgins, the inference there that has to happen is the reach of peaceful enjoyment, and whether or not peaceful enjoyment has sufficient scope to cover the grievances regarding self-determination, gender violence, and pro-democratic struggle that's playing out in Myanmar as we speak. The other two definitions from Mark Allen Gray and the independent expert panel, I see these as being more problematic. Mark Allen Gray has a requirement of an international aspect, that everything that's happening in Myanmar right now is primarily domestic. Particularly the environmental damage has been being contained within the scope of the pro-democracy conflict within the country's borders. The independent expert panel, the situation is that a lot of the international laws that might apply under the international expert panel definition either relate to interstate scenarios, or they are instruments to which Myanmar is not a state party. In addition, the Myanmar military at the moment justifies its actions as being lawful under domestic laws, and it justifies its activities as not being reckless, but instead being something that's necessary because of an existential crisis that's playing out in the country as we speak. So beyond these semantic issues, I also raise some normative complications, and these sort of get to some of the deeper concerns that I have about the ecocide discourse for situations like Myanmar. And there are four in particular that sort of draw my attention. One is an ontological question about a lot of the points that I made regarding intersectionality are very much anthropocentric. And if we start to have ecocide focus on the issues of intersectionality, then there's a very real danger that it skews ecocide and ecocide discourse away from the original intent, which was to try and have some consideration about the environmental harms that are playing out. The second concern that I have is about the nature of remedies, that if we're pursuing ecocide as something in criminal law, that it may not actually provide the kinds of remedies that many of the communities, particularly the indigenous communities in Myanmar, are seeking, which are things like restoration of the environment, self-determination or sovereignty, and in the current conflict, democratic struggle, right, democracy. The third is more about epistemic justice, and some of the previous speakers have raised this, is about the idea of ecocide as an international crime entails a criminal law approach. But for many of the indigenous communities in Myanmar, just like indigenous communities around the world, there is a tendency to look at, or to employ a justice approach that is not necessarily comparable to a Western conception of criminal justice. Specifically, quite often, the concern is about not just the perpetrator, but also the victims and the communities, where the goal is for some kind of restoration for the entire system, not just for the victims specifically. The last concern that I have is sort of the colonial aspect. So again, some of the other speakers have raised this issue, and I raised this with Myanmar itself as well, that if we're talking about ecocide within international criminal law, there's this underlying presumption or perception about some kind of universalism about international crime, international justice. But for many indigenous communities, this is problematic because the aspiration is for a distinctive identity, and that the entire point of self-determination is trying to have some measure of control over the aspects which relate to your own identity. And this can extend to political, legal, economic, social, cultural aspects. And so as a result of this, if ecocide is going to be something that's advanced through international criminal law, I have a very strong suspicion that a lot of indigenous communities are going to raise some concerns about some of the colonial legacies, about prior claims of universalism within the international legal system. I'm going to stop there because I think I'm over time, but I just want to thank everyone for the presentations, and I apologize for going over time.
Thanks for that, Jonathan.
Thank you so much. Good morning, everyone. It's an absolute pleasure to be here. I would like to thank the planners. I'd like to thank the audience for giving me the opportunity to speak, and I would especially like to thank Olivia for moderating. So I am Tamika Samuels-Jones. I'm an associate professor at York University in Toronto, Canada. I'm also the co-director of the Center for Research on Latin America and the Caribbean there. Now, I will not go into the definition of ecocide for my presentation today because it has been done before. My paper is essentially a case study for ecocide as a prosecutable offense, if it does become prosecutable under the Rome Statute. I want to present Jamaica as I want to present some concerns and issues regarding environmental harm and justice in that small island because it's not as known. Now, when most people tend to think of Jamaica, they tend to think of sunny white sand beaches, they think of reggae music, vibrant colors, smiling faces, and in terms of popular products, Jamaica is internationally renowned as well for its vibrant tourism industry and/or potent Blue Mountain coffee. However, what is less known is a primary Jamaican export that is essentially a mainstay of the island's economy, which is bauxite. And that's the raw material from which aluminium is produced. So it's not as well known as tourism or coffee from Jamaica, but it is more widely consumed globally. So for those that may not be familiar with bauxite, it's a sedimentary rock which is mined through extractivism, and then it's refined into aluminium using caustic soda and lime. That aluminium is then used for basic things like windows in houses, electrical appliances, pots, pans, kitchen foil. But important to note is that it is heavily used as well in the Navy for warships. And as a highlight of its importance, 80% of an airplane's weight is also accounted for by aluminium, which gives some level of importance. It attaches the value to this important mineral of bauxite. Now, in spite of its importance, the means by which it is obtained through mining, now that's fraught with problems and contradictions in Jamaica because bauxite causes significant environmental harm. The mining operations entail sacrifice by residents and communities, particularly those within which their communities have been converted into mining concessions. And it significantly sacrifices the environment. It evicts residents and communities from their land, it pollutes water and air, it destroys ecologies, and it demolishes crop areas. And we're going to take a deeper look at some of that as we proceed through the presentation. Now, the origins of Jamaica's bauxite aluminium industry can be traced all the way back to the 1940s by three primary aluminium companies from North America. So the Aluminium Company of Canada, Reynolds Metals, and Kaiser Aluminium. And by 1957, Jamaica was the world's largest producer of bauxite, despite its small nature. The paradox here is that Jamaica's penetration of the aluminium market was viewed as a powerful economic move for the first generation of nationalist leaders in Jamaica. But this move more accurately shifts Jamaica from the economic ties of British colonialism to North American domination. And even today, that bauxite industry in Jamaica is controlled by a tightly knit oligopoly. Now, the areas in which Jamaican bauxite is mined are mostly territories that are inhabited by rural and indigenous populations that have been historically marginalized. And bauxite mining occurs in close proximity to a protected area in Jamaica known as the Cockpit Country, which is what you're looking at right now. Now, the importance of the Cockpit Country cannot be understated. It is valuable for its biological heritage. It is ecologically an island within an island with specially adapted biodiversity that you cannot find anywhere else. In terms of cultural heritage within the Cockpit Country, it's a historic site where Jamaica's Maroons, indigenous Maroons, signed a peace treaty with the British in 1739. And for those of you that may not be aware, the Maroons are descendants of the enslaved that fought with the British in the 18th century. They